the name and title?
Yeah, hi everybody, thanks for coming. I'll just introduce the people up here right now and then give a brief statement about what occurred in the BC Supreme Court just a few moments ago. My name's Kirk Tusaw. I'm counsel to Mr. Owen Smith, who is the accused in these proceedings. And to my left is Mr. Ted Smith, who is the proprietor of the Cannabis Buyers Club of Canada, a medical marijuana dispensary that's been operating for a long time here in the city of Victoria. One of the oldest, if not the oldest, such organizations in Canada. At 9:15 today, we attended in Justice Johnston's courtroom in the BC Supreme Court to hear a decision on a charter application for a remedy pursuant to the charter. On behalf of Mr. Smith, Mr. Owen Smith, we argue that the laws restricting medical production and possession of cannabis, marijuana, to dried product only were unconstitutional because they were arbitrary, because they did not further the government's legitimate interests in protecting health and safety of the public, and that effectively they forced critically and chronically ill Canadians who consume medical marijuana, even under license from Health Canada, to do so in dried form only, and therefore predominantly by smoking, which all parties I think acknowledged was one of the more harmful or potentially harmful modes of ingesting marijuana. We put forward a tremendous amount of patient witnesses and expert evidence, all to the effect that patients would like the opportunity to be able to consume marijuana medically in different formats, either by drinking tea infused with cannabis, by applying oils, topical oils infused with cannabis and cannabis products, or by eating cannabis-baked goods. And we put forward evidence that these modes of ingestion were potentially more effective and certainly potentially less harmful than consuming cannabis by way of smoking it or even by way of vaporizing it. We're very pleased, very gratified that Justice Johnston did declare that the law restricting medical possession and production of cannabis to dried form only did violate the charter, is unconstitutional. The word dried has been stricken from the marijuana medical access regulations, as well as the definition of dried marijuana has been stricken from the medical marijuana access regulations. According to the decision issued just this morning, that will pave the way for persons that are licensed by Health Canada to possess this medical substance and to produce this medical substance to do so in forms other than dry, and therefore it opens up those patients the opportunity to consume it by way of drinking it in teas, topically applying it in oils, or baking it into baked goods or other edible products. Mr. Smith, Mr. Owen Smith, was charged precisely because he was a baker for the Cannabis Buyers Club of Canada, because he, at the time of his charges, was producing oils, topicals, and edible cannabis-based medicines for the consumption of the Cannabis Buyers Club of Canada members. So we're obviously very, very pleased and gratified to see that our arguments on the charter grounds prevailed. Now, the second half of that is that we had also sought a judicial stay of proceedings for Mr. Smith, arguing that an appropriate remedy was not just striking dried from the MMAR, the government's regulatory scheme, but also allowing Mr. Smith to go about his business. The judge denied that remedy. It is an extraordinary remedy, and so the end result of that for Mr. Smith's purposes is that we will be back in court on the 25th of April for fixing a date for a jury trial in this matter, and we hope to convince a jury to acquit Mr. Smith either full stop or on the basis of the common law defense of medical necessity. In other words, because these products were unlawful at the time he was producing it, it was necessary for him to do so to alleviate the suffering of critically and chronically ill Canadians. As I say, we're back in court on the 25th of April to fix a date for that trial. We're also back in court this afternoon at 2 p.m. For the judge to hear arguments on whether or not his declaration of invalidity made this morning ought to be suspended for a period of time in order to allow the government to respond. We will I will be arguing on behalf of Mr. Smith that no such suspension of the declaration of invalidity is necessary. I do not know what the Crown's position will be. We'll probably learn that just before 2, but I'm certainly hopeful that this ruling will go into effect immediately, and the Canadians who benefit from the use of medical cannabis in forms other than dried, other than smoked, will be able to, from today forward, do so without fear of arrest, prosecution, or possible imprisonment. So that's what happened this morning. If you have any questions for me or for either of the Mr. Smiths, we're happy to answer them.
Do you expect the government to appeal the win?
Well, that's for the government to decide. Certainly in previous cases involving the constitutionality of the medical cannabis access regime, the government has appealed adverse rulings, largely unsuccessfully. So it would not at all be a surprise to see this case reach the Court of Appeal and perhaps even the Supreme Court of Canada at some point.
Can you explain why, despite the fact that Judge ruled that Mr. Smith's constitutional rights were violated, he still has to face trial on this?
What the judge said was really twofold. First, the remedy of a judicial stay of proceedings is an extraordinary remedy granted only in the clearest of cases. Because the government has a compelling interest in regulating marijuana, even medical marijuana, the judge was not prepared to grant that extraordinary remedy to Mr. Smith. We had also argued that the government's response to prior decisions in this area were essentially in bad faith, because each time this program has been ruled unconstitutional, the government's response has been to make very incremental changes. The court was not prepared to accept that argument, predominantly because at the end of the day, cannabis for non-medical purposes remains unlawful, and the government has a vested interest in regulating unlawful conduct. I don't think all Canadians agree with. In fact, I don't think most Canadians agree with the prohibition of marijuana generally, but the Supreme Court of Canada has said it's within the power of the Government of Canada to make it illegal despite the harms that flow from prohibition. And so the judge was not prepared to grant a stay of proceedings on the basis that here in the medical field, the government has been slow to put a system into place that really services all of these sick and suffering citizens that benefit or could benefit from this natural health product.
So is Mr. Johnson saying then that it really will still have to be up to a court to decide whether whatever Mr. Smith did, there were other elements of a crime that may have been committed that have nothing to do with the actual constitutional ruling on, the dried or baked product?
Yes, the context of today's decision came because of a charter application and a voir dire, which is a trial within a trial. It was really a preliminary trial on the issue of the constitutionality of the restriction in the MMAR to dried cannabis only. It was not to decide the guilt or innocence of Mr. Owen Smith. A jury will decide that at some point in the future, and Justice Johnson's ruling today simply allows that process to go forward.
Owen, I'd like to step over to you if we could. How do you feel? There's this constitutional win based on the case you're involved in, yet you're also still facing prosecution.
Yeah, well, I'm really proud of all the work that we've done so far. Lots of the patients and members of the club have been very supportive, as well as other people from the community. So we're going to keep going, and we'll do just as good a job in the next round in front of a jury as we did in front of the judge, I'm sure.
Do you have faith that a jury will find that what you were doing was for medical purposes and that you're in the right?
Yeah, I do. Absolutely. Yeah, it's hard to think that somebody would want to deny somebody a safer form of medicating and essentially forcing sick people to smoke. That's against most people's common sense.
When this is all over, will you go back to baking?
Oh yeah, I've continued baking.
What went through your mind when the judge said unconstitutional?
I felt a flutter in my heart, but I got to read through the decision to really get my mind into it.
What about you, Ted? What are you thinking will be the outcome of all this?
Well, I think the ultimate outcome will be the cannabis laws will be, struck down and changed, and people that use it medically ultimately will be subsidized and will be singled out. This, to me, is a great step towards patients' abilities to control their own medicine. We took THC and cannabis away from pharmaceutical companies this morning and put it back into people's backyards where they can make their own medicines.
Very surprised.
I wasn't surprised it was ruled unconstitutional. I obviously have a firm belief in the law being wrong. I was surprised that we are going ahead with the jury trial. So that was the part that caught me off guard. But I'm not at all intimidated by that any more than I was intimidated by going in front of a judge. I'm very confident that no jury in this country would convict Owen for making the cookies and skin products. So that is another opportunity to change public opinion. Today we changed the law.
So, and it sounds like to you, this isn't a story about pot, marijuana. This is a story about medicine, and everybody's right to it. And maybe you can speak a bit more about that, because I think some people will listen and go, oh, okay, it's it's a pot trial,
This has much broader implications into the necessity of the drug approval process, and also whether cannabis should be even included in the Controlled Drugs and Substances Act and should be included as a natural health product. There are a number of plants that have been made illegal for people to grow and produce medicine from in order for drug companies to make money from. This plant, cannabis, has a treasure trove of different chemicals that have medicinal value in it that we're just beginning to discover. Drug companies are frothing at the mouth at the potential to make billions of dollars off of the public from this. The public doesn't need to pay drug companies for this medicine. The public can grow it in the backyard with their roses.
Thank you. Can you continue representing Mr. Smith?
Yes, absolutely. If Mr. Smith wants me to continue representing him, and I hope that he does, I'm certainly happy to take this to a jury. I'm happy to take this to the Court of Appeal, and I anticipate and hope that we'll continue to have success, because at the end of the day, I think most Canadians understand that the government ought not to be imposing arbitrary restrictions on access to medicine that actually have the effect of harming people's health rather than enhancing it. And I'm very confident that we can convince a jury of that, and I'm equally confident that we can convince the Court of Appeal and even the Supreme Court of Canada of that fact. It is really past time for us as a society to open up access to this natural health product, to allow people to use it in all the variety of ways that humans have historically used it for thousands of years with virtually no negative effects. And so this, as Ted Smith said, this is really another step in the progression of not just the issue of medical marijuana, but the progression of us as a society towards a time when patient autonomy prevails over pharmaceutical profits. And I think that that's a critical step for all Canadians, not just those who benefit from medical cannabis. That's anybody's guess. I mean, we've got to determine how much of the evidence that was put in the voir dire we can put in directly without the need of calling additional witnesses. We don't know how long the trial is going to be. I don't know what the Crown's position on various issues is going to be. I'd be surprised if the jury trial was less than 2 weeks. I'd be equally surprised if it was more than 2 months. So best guess, earliest summer, likeliest fall, or even later for a jury trial in these proceedings. But we'll know on the 25th of April. Yeah, I think the bottom line today is that Justice Johnson ruled that the restriction to dried marijuana only was arbitrary, violated Section 7 of the Charter, was not saved by Section 1 of the Charter, and we'll find out at 2 p.m. today or shortly afterward whether that goes into effect immediately or whether the government's going to be granted some time to attempt to remedy the unconstitutionality of its system. Thanks, everybody.
Thank you.
Thank you for coming, everyone.
Okay, can we have one